So now it's better.
Your time starts only now.
Okay. Okay. So, for if justice perishes, there is no longer any value in humans living on earth. This writes Immanuel Kant, referring to our nature as reasonable beings. Justice is the basis and function of the law. This is the aim of jurisprudence as the science of what is just and what is unjust. It provides the measure for practical reason, for the basis for the basis for the order of our liberty in society and economy. So let us start with Britain. It influenced the development for decades, overwhelmingly in practice through the actors in the City of London and its outliers, especially New York's Wall Street. In May 1991, the Cadbury Report focused on financial reporting and auditing. The committee sponsors were, bring the citation, were concerned at the perceived low level of confidence both in financial reporting and in the ability of auditors to provide the safeguards which the users of company reports sought and expect. It is emphasized, the report said, the underlying factors were seen as the looseness of accounting standards, the absence of a clear framework for ensuring that directors kept under review the controls in their business, and competitive pressure both on companies and on auditors, which made it difficult for auditors to stand up to demanding boards. This means there is a lack of clear, strict norms, you might say, a lack of legal order at all. The Cadbury Report marks the beginning of a global movement to anchor privately formed codes of corporate conduct. They are accompanied by standard setting, so-called standard setting for financial reporting and auditing, most of all the International Financial Reporting Standards, IFRS. By mere numbers, it has been a story of success around the world. However, numbers are merely the sign of total limitation. The facts betray the catastrophic irresponsibility of the mathematically trimmed economy, at the latest with the fall of Lehman Brothers. Since then, we have been witnessing massive distortions around the world at all levels. The Financial Times summarized the year 2015 with the following title. I give the citation: "Bankers strain against shackles. The financial world is a way off recovering from the crash of 2008. Need more? The list of scandals is growing drastically worldwide. The range is wide, occasions and forms have manifold effects. Basically, however, there's always a lack of the diligence, you might say the ethics, necessary on the part of those responsible. In general, there seems to be hardly any sense of responsibility at all. Present practice appears to be a grandiose failure, intentionally shifting and accumulating gigantic assets. What is required now in the relationship of economy and state is the description of a morally conceived good economy. We aim to establish internationally an order of assets that is based on freedom and responsibility of the individuals. Let's make it here in 7 steps. The discourse about good corporate governance internationally centers around the corporation. What is a corporation? In the famous words of John C. Marshall, it is an artificial being, invisible, intangible, and existing only in the contemplation of law. From this stem practically all questions of good corporate governance regarding entrepreneurial care and the liability of those individuals acting personally responsibly. Basically, is all about lawful financing and thus about valuation and the obligation to provide information to current and potential investors. Disclosure. For managers, this means, well, let me add first, this is always and also shown by the comply or explain approach in corporate governance. If behavior and explanation of the directors are unsatisfactory, the shareholders may make use of their right to hold the company to account. For manager, this means for the way they deal with other people's money. The underlying principles of all good corporate governance are generally valid: accountability, transparency, and probity. But what the corporate managers are fixed on? Their model of management seeks to maximize the reported earnings per share or the reported free cash flow. That means creating shareholder value has become their board maxim, a game of prognosis and models of vague expectations. Worldwide, this led to the development of earnings management, described by Arthur Levitt in 1998, then the SEC chairman at Wall Street, as follows. He said, "The numbers game among market participants, a game of nods and winks, where the accounting is being perverted. Systematically, massive accounting and market manipulation took place, as with Enron, WorldCom, then Lehman and Goldman Sachs, Deutsche Bank, abuse of investment banking and structured finance products, so-called CDO Ponzi schemes, inflated credit ratings, high-risk lending, and so on." The right list of scandals continues to the present, and that means that we are still teetering on the brink of the abyss. Good corporate governance means adequate protection. Well, this is not neat. Already. Good corporate governance means adequate protection of investors, and that means equity and debt investors, of course, for sustainable participation in business success. The valuation of the assets of the corporation is elementary in the governance concept. Corporate governance is, says the UK Code, about what the board of a company does and how it sets the values of the company. However, value is a colorful word also when it comes to the mentioned concept of accountability, transparency, and probity, that is regarding fair value. Fair value measurements and disclosures remain problematically internationally. And this is all the more true since the IFRS dematerialize valuation according to their muddy model of US GAAP. The central accounting concept, assets, highlights this, referring to any resource controlled by the corporation from which future economic benefits are expected to flow to the entity. This approach is oriented towards the future, based on the concept of probability. That is not accounting at all, and no information. It is swampy ground. It's like looking into a crystal ball, like in medieval times. Good corporate governance, and that means control, requires true information, and that means facts. They are lacking under IFRS as well as under US GAAP, for no truth may be known from the future. For the order of corporate governance, it is irritating to ask whether a soft or a hard law approach should be taken. There is no law without clear, enforceable norms. For where the law ends, that means arbitrariness takes hold, tyranny begins. As John Locke wrote on civil government as early as 1690. Basically, the prerogative of interpretation takes effect. How are values determined? Valuations regulated, carried out, and, in the last instance, controlled. From the perspective of the theory of equilibrium, fair value is a product of complete markets. In the regulated industries, let me pick that, because free markets today no longer exist. Most are being regulated. There are specific rules of accounting, as telecommunication shows. The Federal Communications Commission, the FCC in the US, sets rules for adequate tariffs, and that means prices for services of public interest, so-called pricing methodology. The more recent approach, according to the FCC, encompasses the total element long-run incremental cost of the element. The US Supreme Court accepted the interpretation. And to make a long story short, the judges say legally the general use of cost did not clearly imply past cost, that means historical investment, and has figured in contemporary state and federal rate making untethered to historical valuation. Without any better indication, they said, of meaning than the unadorned term cost, as in accounting generally, is a chameleon, a virtually meaningless term. End of the citation. Well, the real scandal in this Verizon case is that judges do not criticize that cost, in spite of being the core of the regulation, is an unadorned term. Yes, even a chameleon, a virtually meaningless term. They even emphasize the usualness of this practice, as they say, as in accounting generally, and do not find a fault with it. Whereas the constitutional commandment of definiteness gone too. This requires fair notice about the content of the rule, due process. This is true overall for corporate governance, disclosure and valuation, shaped by the directors. Regarding this powerful weapon, out of Burl and Gardiner means already a remarked citation, so long as accounting standards are not hardened and the law does not impose any specific canons, directors may frame their figures within limits much as they choose. And with foresight, Adolf Burl wrote on the discourse about the general publicity of corporate accounts in the 1920s already, citation, a corporate management which as individuals chooses to enter the open market and which at the same time exercises control over the release of information concerning corporate affairs can deal with the current value of its securities, if not at pleasure, at least with tremendous effect. And the liquid value of the corporate securities held by the stockholders becomes a matter which the corporate management itself can determine. This is especially true in the dominance of numbers shaping economic theory and practice, and this means shifting wealth, privatizing profits, socializing losses. That is not initiated by a so-called invisible hand, but by the absence of a strong regime, and that means regulation of valuation and disclosure in general are needed, but both remain rooted privately in the US, and so in the rest of the world, you might say, along with a prerogative of interpretation. With corporate governance and its regulation, the issue is the liberal society and its proprietary commercial order. The key question remains as to whether judges examine and correct private economic arrangements. That is indeed a wide terrain, a bumpy road. All the more, economic predictions are to be avoided and the facts to be clarified. This is no different in financial reporting or disclosure overall than in other areas of life, let's say, for example, in product liability. The judge must investigate the relevant facts of the case under the commandment of truth and weigh them for his or her decision, so-called fact-specific inquiry. Sustainable norms of valuation and publicity are necessary for good corporate governance. And as early as 1928, again, Adolf Burl took it into the following focus: requirement of disclosure has to do with facts only and not with prospects, hopes, or estimates. Law, economy, and society cannot tolerate haphazard estimations, presentations of future earnings, appraised asset valuations, and other hypothetical data are to be discouraged. For otherwise, and that's the real point, sham profits, and that means the substance of the corporation will ultimately be distributed according to the periodization principle of accounting law. Basically, disclosure with fair value is all about substance, and that means about truthful reporting. Where market prices are lacking, disciplined valuation on the basis of facts must take place. conceptually clearly characterized as hypothetical data, as hypothetical value, and to be examined by a court in the last instance. So man is in the center. As in any area of life, man decides whether good comes into the world. It is about reason and morals on which the law is based. This obviously does not cover achieving financial results, and that means personal gains by manipulation. Regulation is to provide practitioners with a measure and to keep measure itself, avoiding over-regulation. Forcefully, Adam Smith, the moral, philosophical, economic advisor, completely discarded casuistics, which only he believed frightened nice exactness. Instead, he laid the emphasis on justice, modesty, and veracity as our, as it were, eternal principles of action. And this brings people and markets together. The community establishes a substantial order for human cooperation and not individual circles short-sightedly directed towards particular interests. And this is achieved through rules fixed by a standard of reasonable prudence, whether usually is complied with or not. They provide the necessary measure and care, and of course liability. They mean to present fairly. With these insights, we can focus on just foundations. Good corporate governance is elementary for prospering communities nationally and internationally. What is required is a faithful action and faithful accounting in dealing with other people's money. And truth is the imperative procedurally built on facts. This applies in particular in the face of dematerialization that believes in the future. Soft information, meager money managers, intermediaries, high-frequency trading, dark pools, and the like. For fundamentally, it is about the control of power. That is why individual liberty and individual responsibility are inseparable. The law relies on private autonomy as the expression of humanity, the responsible power of judgment of the actor in a sound market order. To this end, the law determines mandatory rules as the yardstick in the sense of the ratio legis. First, for the diligence and liability of directors in general. Second, for their duty to inform, to present fairly the corporation in the financial statement as a whole. And third, for the audit. For valuation, accounting, and auditing are legal acts. They are, however, widely lacking, which shows the basic evil of the economy of catastrophe we are witnessing. Corporation law, the usual fuss about shareholder value and activism, decision usefulness, etc., will come to nothing as long as, first, the substance of corporate governance is not clearly and faithfully documented and an independent investigation has not taken place, and this documentation had not been legally investigated according to the truth on a conclusively substantiated request of an investor in case of conflict. This procedural concept of truth at the same time protects directors who act duly. They can avoid with that liability. Principally, the following applies: where somebody responsible deviates from norms and facts, he loses this protection of the law, which he himself is avoiding. This does not mean retreating into vagueness or casuistics, into the numbers game according to US GAAP, so what is called cooking the books, lacking the spirit of the law. Corporate directors should simply inform fairly, give a true and full account of the corporate affairs, and that means the good, the bad, and the ugly. So Confucianism, being here in China, may be some kind of hint in a harmony of economic and ethics, sees virtue as the root and wealth as the result, and so does our Western idea of humanism. This is what sustains good corporate governance, regulated and protected in an international order of assets in a liberal way through a law, and enforcement may then commercially serve the common good in the sense of an invisible hand. At the individual level, the acting person remains responsible according to the reason and spirit of the law, and of course, according to the rules. So, let's sum up. We, the people, I might say, need a Copernican turn of financial actors towards the truth commandment, an order of assets with sustainable financing and valuation. Mandatory financial information is at the heart of entrepreneurial organizations, business activity, and disclosure. So what is required is a paradigm change from economic mathematical arbitrariness to the primacy of the law. The prerogative of standard setting and interpretation belongs in the hands of independent legislators and judges instead of private interest groups. Otherwise, the corporation, and with it our markets and communities, will further degenerate into an ingenious device for obtaining individual profit without individual responsibility. Thank you very much for your attention.
Thank you, Klaus, for taking the time. So
Thanks.
we'll take some questions now. Yes, Kate.
Klaus, I'm intrigued by your focus on personal responsibility. I want to talk through that a bit. I tend to be a skeptic of personal responsibility as a touchstone for law, mostly because I think people are situational, and mostly personal responsibility and freedom personal responsibility is less certain a protection than law. So, here, and I wonder if this is if one's fundamental understanding of human nature derives these kinds of legal choices, right? Like if you think human beings are mostly good and need to be liberated by law to act well, then you would want law to step aside. If you think humans are situational, you would want law to constrain them and channel their efforts toward good. I mean, so Madison, James Madison in the U.S. constructed the American system of government because he could not trust men to be angels, right? He thought that even people acting poorly, constrained by checks and balances and the government system, would force them in effect to act well. And I wonder. So I'm just inviting you to think more about this as a philosophical question, and how does it drive your views?
Of course, I did view it as a philosophical question because I mentioned the good is only coming into the world by man. So that's the point. I mean, we can come up with rules, and we need rules, obviously, because man need rules in a society and in business. That's kind of what we talked about on legitimization of rules. So you used the word constrain. We need to constrain people, obviously, in their behavior so that they have some measure in the business world, for example, to cling to. So not running out of control. As I mentioned, it's all about control of power, basically. So if you trust people, of course, you don't need any rule at all, maybe. But up to our experience today, we know that those people running businesses need those rules. Otherwise, there is no control. And they're going to the extreme. So what I'm trying to focus on is that the financial basis of a corporation, and I mean, we must notice what is a corporation. A corporation is basically an instrument of finance. That's the only reason to come up with a corporation. to finance a business. And therefore you need capital. So people are providing capital, investors, and they need some kind of protection. And this protection is coming from what you call constraint on corporate directors. But the whole field of financial reporting is lacking those constraints. There are no really measures, if you know, and recall what I cited from the US Supreme Court, that he said, well, such a concept like cost, which is very central in the financing and the price setting, is totally meaningless, and directors can do with it what they like. There is no control or no constraint, as you mentioned, at all. So that may be because legal business at all, or lawyers you might say, are since decades are not aware of the centrality of the financial and valuation problem. So they're avoiding everything, well, you might say, connecting with numbers. Let me trace it back to what we discussed on this topic of accountability. What's accountability? I mean, there has the word's been said, accounting. Accountability is accounting. And if you put it the way it is mentioned in the IFRS financial reporting, I mean, accounting and reporting does say the same. They are synonym, basically. And going back into the etymology, what reporting means is to report. It derives from the old French rapport, or even older from the old Latin reportare. That means re, back, and portare, carrying. To carry something back, what needs to be carried back during financial reporting. It's exactly what I mentioned. Investors giving capital to the corporation used by directors, and the directors use that money of other people. So they need to bring back the money, and of course maybe a return on investment, but at least they need to inform the investors. They need to come back with solid information what they've done with the money. So that's all about what reporting is. So, but if there are no constraints and no rules, this whole thing is running out of control, as we now see.
Can we take a few more questions?
Yeah, please.
You made some fascinating points, and I was desperately trying to work out what you were proposing for financial reporting. Correct me if I'm wrong, but you seem to be saying that accounting standards as a whole lack validity, and that you would move that to the legal arena. So explain to me how you, how your world would operate for financial reporting.
Well, actually going into the history, especially of the US, you will come to the point that the Congress in the 1930s got the power to come up from the legal side, from Parliament, with standards of reporting and accounting and auditing. But the private industry, only 5 or 6 years later in 1936, took over. So then the FASB or their predecessors, whatever their name had been, took over. And the power to establish real standards like we, for example, in continental Europe, rest with a parliament, with a government, were shifted onto the business side of private actors. So they came up with what's today called the so-named US GAAP. But there are so different resources under this label US GAAP that there is no real standard setting, because there's only, well, necessary me, for example, as a professor can come up with some opinion, and that has so-called authoritative report, support then giving in the court if a question is coming up in front of the court concerning valuation. So there is no real, no neutral standard setter. It's just serving the interests of private businesses. And that's what at the core is of all that mess that we are in.
So you'd still have standards, but they would be standards that are promulgated by the courts or by Parliament?
By Parliament, first of all. By Parliament or by, let's say, some kind of governmental institution like the SEC. I mean, the SEC could set standards, but they're avoiding to do that.
No, I'm afraid I have I hate to do this, but I have to step in to stop here. But I'm sure we will have an opportunity to continue because it's going to be a panel discussion now. So please feel free to continue the discussion thereafter, but maybe I'll step out. And before I do that, we have this honor to do, I have this honor to present this to you, Klaus.